According to recent filings, lawyers representing plaintiffs in a landmark multi-billion-dollar settlement against the NCAA and Power Five conferences are requesting nearly $525 million in attorney fees and costs. They also seek the right to request up to $250 million more annually over the 10-year settlement period. The total amount would be paid out over 10 years. The plaintiffs' legal team is led by prominent attorneys Steve Berman from Hoggins Berman Sobel Shapiro LLP and Jeff Kessler from Winston & Strawn LLP. This comes shortly after U.S. District Judge Claudia Wilkin granted preliminary approval to the wide-reaching settlement agreement, which could significantly alter the college sports landscape. The deal includes a $2.8 billion damages pool to compensate current and former athletes over the next decade. Additionally, it allows Division I schools to begin directly compensating athletes for using their name, image, and likeness, nil, subject to a per-school cap, which will increase over time. The initial nil cap for the 2025-26 school year is expected to be between $20 million and $23 million. One of the most significant changes in the agreement is that Division I athletics programs will no longer be subject to the old sport-specific scholarship limits, but will instead follow sport-specific roster limits. For example, the roster limit for football will increase to 105 players in the first academic year after the settlement's final approval. Many Power Five schools have had rosters exceeding 125 players, suggesting that this change will allow more athletes to be compensated. In addition to the $525 million requested for attorney fees, the plaintiffs' lawyers are seeking the right to apply annually for a percentage of the amount spent by Division I schools on nil agreements, new scholarships, and academic achievement awards that result from the Supreme Court's 2021 Alston decision. The requested percentage ranges from 0.75% to 1.25%. If all 68 Power Five schools each provide $20 million for nil agreements, this could amount to $1.36 billion annually, with the potential for additional payments from other Division I schools. The settlement agreement is still pending final approval by Judge Wilkin, who has scheduled a hearing for April 7, 2025, in Oakland, California. If there are any appeals, the settlement details, such as nil payments and roster limit changes, could begin as early as the 2025-26 school year. Still, the payments to plaintiffs' attorneys and damages to athletes will be held in escrow until appeals are resolved. While the proposed settlement includes a $2.8 billion damages pool, plaintiffs' attorneys argue that the actual value of the settlement could exceed $20 billion over the next decade. This settlement could revolutionize college sports and allow athletes to earn revenue percentages similar to professional athletes in the NFL and NBA. The plaintiffs' lawyers have emphasized that this case, which they describe as a bet the company case, could lead to one of the most significant recoveries in antitrust history. They further argue that their requested fees, representing 18.3% of the cash common funds, are reasonable given the scope and significance of the settlement. With the total value of the settlement potentially surpassing $20 billion, the lawyers assert that their fee request represents just 3.2% of the total value, which is consistent with benchmarks in other cases within the Ninth U.S. Circuit Court of Appeals. This settlement could set a powerful precedent for how athletes are compensated, potentially reshaping college sports for years to come.